What to do in the first 72 hours after military allegations arise. Senior NCOs and officers, the same military lawyers you've trusted your entire career, just became your enemy. Here's what nobody tells you about military allegations. It does not matter if you're innocent. What matters is whether there's evidence that supports the allegations. And unfortunately, even the most innocent of evidence, text messages, GPS data, photos of you and your family on your phone, can be used by prosecutors to make you look guilty of crimes you never committed. And at the end of the day, if you do go through a court-martial, the question at that court-martial is not, is it true that something happened? That's just not what we're talking about. The real question is whether there's evidence to support what the government is claiming. And if you don't go to a court-martial and instead there's some sort of administrative action, the standard is lower, and once again, the question is whether there's evidence that supports the allegations, not whether something truly happened. And the way the system really works is that there is evidence that actually exists, but is innocent evidence that ends up supporting the allegations that are false. I'm Joshua Tolin, and I've spent years defending senior military members who thought they could handle allegations the same way they've handled everything else in their careers. They were wrong. By the end of this video, you're going to understand what you need to do as soon as allegations come out and how to protect yourself when your world gets turned upside down. Because let's be real, we're not just talking about a court-martial here. We're talking about your reputation, your retirement, your family's financial security, and everything you've worked decades to build. The mindset shift. So first off, the most important thing to recognize when allegations come out, especially for senior NCOs and officers who've been around for years, is that you are in a completely different position than you have been your entire career. Throughout your career, you've relied on the Office of Staff Judge Advocate, Air Force JAGs, Army JAGs, Navy JAGs. You've relied on those JAGs throughout your service to give you legal advice when situations arise. But here, military criminal allegations against you put you in a complete opposite realm, where those same staff judge advocates, those assistant staff judge advocates, those lawyers that you've relied on forever and always are now on the other side. Let me say this again because this is critical. The staff judge advocates you've trusted your entire career are now advising the command. They are working with investigators and they are not there to protect you. And here's what makes this so dangerous. Most senior officers and senior NCOs do not recognize this shift fast enough. Their initial reaction is, I've worked with this person for years. They know me. They know I'm not this kind of person. So they call the SJA. They explain. They think they're just having a conversation with someone they trust. What they don't realize is that everything that you say can be documented and used against it. I've seen this happen. So the first step is recognition. Recognizing there is a serious chance for serious personal ramifications, and recognizing the common steps you normally take. Calling the JAG you rely on is not the answer here. Step one is simply recognition. Know your 3 critical rights. Step 2 is knowing what your rights are in the military. There are 3 rights that are most important for you to recognize at the very beginning of an allegation. When someone you trust lets you know that there are allegations against you, or there might be allegations against you, these 3 rights become critical. Your right to remain silent, your right against unreasonable searches and seizures, and your right to an attorney. Now, chances are, me saying these out loud right now, you're thinking like, yeah, I understand those rights. But you really, truly have to understand those rights from the perspective of somebody accused of a crime. Knowing them as a senior enlisted leader, knowing them as a commander, knowing them as somebody else's mentor in the military is completely different than knowing them as somebody who's been accused of a crime. So let's break those down. The right against unreasonable searches and seizures. The first thing I like to say is lock down your shit. This is important for you to understand. You have a right against unreasonable searches and seizures, which also means you have a right not to consent to your personal private information being out there. In 2025, one of the things that hardly anybody leaves their house without is their personal mobile device. And inside those devices is an enormous amount of data about you as an individual. Personal information, personal text messages, locations, who you called, when, who you said what to. All of that information is tied up in your personal mobile phone. Here's how the law works. Even if there is no search warrant, even if there's no reasonable search and seizure granted by some sort of authority, an investigator simply has to ask you for permission. Hey, do you mind if I look through your phone? And usually they do so in such a calm, very polite way. And even if you've exercised your other rights, even if you've requested a lawyer, even if you've agreed not to answer questions, the law allows investigators to ask you for consent to search. This is so dangerous in the military because we are trained to recognize authority. Even when we outrank somebody, we understand positional authority. And when you're sitting inside interrogation room, even if you outrank that investigator, you understand they control the room, not you. So when we're talking about military members, it is incredibly easy for investigators to get consent to search someone's personal property, especially when the person sitting there knows they did nothing wrong. Their initial thought is, I didn't do anything wrong. My phone will show that. My phone will prove this is not true. But unfortunately, courts-martial and serious criminal allegations against senior NCOs, against officers, are not about the truth. And when you hand over that phone, that innocent data can be used against you. To be clear, maybe you did something wrong, but maybe it's not the criminal allegation they're saying. Maybe there's been no misconduct at all. But messages show communication. Messages show meetings. Messages show familiarity. Messages show timing. Messages show an opportunity to commit a crime. And those individual pieces of evidence can be built one on top of another to be used against you. When I talk about defending people accused of crimes, I'm not just focused on full-blown litigated courts-martial. An experienced military lawyer looks at the whole picture. What happens to your reputation? What administrative action may be taken? What about the stuff that never even makes it to a court-martial? How to actually lock down your property? Going back to knowing your rights and understanding that you have a right not to consent, you also need to make sure your property is actually locked down. The way the law works is this. If the government has access to your property, or if you grant access, or if someone with authority grants access, then they don't need search authority. They can just use what they find. So, how do you lock things down? Number one, lock down your house. When you're accused of a crime, you and your family need to understand that you do not invite law enforcement into your home without a warrant. Number two, lock down your other possessions. Don't leave your vehicle unlocked just because you're on post. Don't leave personal items unsecured. And the most important piece of property to lock down is your mobile phone. The massive amounts of data in our lives are on your phone. Photos, messages, voice recordings, GPS logs, search histories, ChatGPT prompts. That information exists whether or not you did anything wrong. And even the most innocent information can be used to support an allegation. The biometric security problem. Not only can investigators ask you to search your phone, they can also get search authority and then ask you to help them open it. One of the ways they do that is just by asking you to put in your passcode. If that happens, your response should be simple. I would like to speak to a lawyer first. Because at the end of the day, whether you ultimately are actually required to open your phone is very case specific. It depends on exactly what they say to you, exactly what the order says, exactly what the law is at that moment in time. What the law clearly allows right now is the use of biometric information. Your face, your fingerprints. Most phones and tablets allow you to unlock them with biometrics. And while that makes life super convenient, it also makes it much easier for law enforcement to get access to that property. So, if you are accused of a crime, or you think you might be accused of a crime, those biometric security measures should be removed for the time being. Is it inconvenient? Yes. Is typing in a password on your phone annoying? Yes. Is it worse to have evidence used against you for something you didn't do? Absolutely. Instead, you should use a password with both letters and numbers. Not your birthday, not your address, not your pet's name, not something shared with your spouse, not something from the dictionary, an alphanumeric password that only you know. Once your property is locked down and you recognize you should not consent to searches, the next right you truly need to understand is your right to a lawyer. The United States Constitution guarantees this right. But there is an important distinction in the military. Most people believe that the military defense counsel that exists are required to be provided to you just whenever you're read Article 31 rights. But that is not the law. You do not have the right to a military provided defense counsel until after charges are preferred. You do have the right to ask for a lawyer. So if you're accused of a crime, you just simply say, I would like to speak to a lawyer before doing anything else. If they then ask to consent for search, respond again. I would like to speak to a lawyer first, please. And then this part is critical. You must actually go get a lawyer. To be clear, there is no requirement for CID to provide you a lawyer. There's no requirement for law enforcement to connect you with trial defense services or the area defense counsel or other military counsel. In the last couple of years, there was a case at the Court of Appeals for the Armed Forces where somebody understood their right to a lawyer and in fact invoked that right. But when he went to his services military counsel, he was not detailed somebody. And so what did he do? He went back to investigators, answered their questions. And that evidence was used against him where he was convicted at a court-martial. That, of course, is the wrong move. If you ask for a lawyer, you wait, and then you go find one. If you have the resources, you should hire an experienced military lawyer immediately. Someone who not just understands military law, but criminal military law, and also understands senior leaders, careers, and your reputation at risk. Your right to remain silent. The third right you must understand is your right to remain silent, and not just understand it, exercise it. Once you lock down your property, requested a lawyer, you should say nothing else. This is where you turn to just listening mode. Listen to what crime you're accused of. Listen as they read you your Article 31 rights. Listen to what your first sergeant says. Listen to what the law enforcement says when they're around you. Listen to what your unit has to say. And your right to remain silent doesn't just stop with investigators. Do not talk to your first sergeant. Do not talk to your supervisor. Do not talk to your colleagues. Do not vent to your friends about these allegations. Every conversation about these allegations creates witnesses. Even if you tell the truth, even if you say the same thing to different people, people remember things differently. And when people remember things differently, that can be used against you at a court-martial. So instead, exercise that right to silence, not just to law enforcement, to everybody around you. Just listen, take notes mentally, and keep your mouth shut. Preparing the counteroffensive, the 4 pillars, and the long game. Preparing the counteroffensive. Once you've actually recognized what's happened, once you've exercised your rights, locked down your property, and found yourself an experienced military defense lawyer, the next step is preparing the counteroffensive. And that should happen immediately. Not months later, not after charges are preferred, right away. So how do we set up a counteroffensive? An experienced military defense lawyer will use a strategic military defense framework built around these 4 pillars. The 4 pillars: what they think, what we know, evidence they have, and evidence we can get. I'm going to say that again. The 4 pillars are what they think, what we know, evidence they have, and evidence we can get. Now, these pillars change over time as a case develops, but that initial battle plan, the one created right at the beginning, is based on where those 4 pillars are at that moment in time. Pillar 1, what they think. What they think comes from you listening. Remember when I said you're going to listen to what crime you read under Article 31? You're going to listen to what your command says. You're going to listen to what your trusted first sergeant says. Listen to what the investigators say and what they don't say. An experienced military defense lawyer will also engage prosecutors when appropriate because prosecutors, the best of them, often understand the importance of working with experienced military defense counsel. That information helps determine what the government believes happened. Pillar 2, what we know. What we know is what actually happened in the real world. It is critical that your lawyer hears your full account as early as possible. If your lawyer does not want to hear what actually happened, that is a giant red flag. Your lawyer knowing what happened allows the lawyer to avoid serious mistakes, including asking the government to obtain evidence that could harm you. Good lawyers need the full picture. Pillar 3, evidence they have. Evidence they have usually comes through discovery after charges are preferred. Sometimes experienced defense counsel can learn what evidence exists earlier. The sooner this pillar is understood, the better positioned you are. Pillar 3 is where other defense counsel who say there's nothing we can do until charges are preferred, they're focused only on Pillar 3. Pillar 4, evidence we can get. This evidence includes evidence the government doesn't have, evidence that can be preserved, and evidence that can be obtained strategically without the government's knowledge. Sometimes Pillar 4 is just about trial arguments. Sometimes it's about discovery violations, what we've asked for, what the government hasn't provided, and why that's bad. Sometimes it's about what evidence not to request just because we can. Now, all 4 pillars work together to determine the strategic military defense. The long game, your reputation and performance. Here's something that often goes overlooked in military law. Even with a great legal defense, your lawyer cannot fix your reputation alone. You must continue to do your job. Put your head down, be professional, be reliable. People will remember how you showed up during this time. Those people may testify later on your behalf. Not just about who you are as a person, what you did before the allegations, but also how you handled yourself afterwards. Whether it's the end of a court-martial or administrative action or separation, at the end of the process, your reputation matters. And the way you protect it is by staying disciplined, staying quiet, and staying focused on the mission. So let's recap. Recognize what's truly happening. Understand the system has changed. Exercise your rights. Lock down your property. Remain silent. Hire a lawyer. And prepare your counteroffensive now. Remember, criminal allegations change everything. And the way you respond will have lasting consequences for your career, your family, and everything you've worked for. If you found this breakdown helpful, make sure you subscribe. And if you know somebody else who's interested in the truth about military law, share. Understanding how the system actually works is the first step to protecting yourself and the people you love.